Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and immigration. Today we are going to speak about visa options for landscaping workers for the United States. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. If you are a US company and you would like to hire foreign employees for landscaping positions, then you have two visa options available to you to bring these workers to the United States. One is the H-2B visa program, which is for temporary work in the United States, and the second one is the EB-3 visa for unskilled workers, which is for permanent full-time labor in the United States, and it is a green card. Now we are going to discuss these two visa options in more detail so you learn how you can use them to bring foreign workers for your landscaping positions. 1. H-2B visa. With the H-2B visa, you are able to bring foreign employees to the United States to work for you on a temporary basis for a period of 3 to 10 months, and only in rare circumstances you can bring the employees for a period of up to 3 years, and this depends on your need. So, if your company has a seasonal need or a peak low need for foreign workers during a fiscal year, then you are able to bring employees to the United States on H-2B visas for up to 10 months. However, if your company has a one-time need for these foreign workers, then you may be able to petition and obtain approval to bring the foreign workers for up to 3 years. Now you need to keep in mind that your company needs to be able to prove its need to the United States Department of Labor, and you as a company need to take the required steps in order to obtain H-2B visas for your foreign workers. The H-2B visa process starts at the Department of Labor, and now we are going to speak about when should you start the H-2B visa program. The best time to start the H-2B visa process is as follows. If you plan to hire your employee with a start date of October 1st of any year, then you will need to start the process for the H-2B visa all the way in March, April, or the latest mid-May of that year. This is because you will need to file a prevailing wage determination with the United States Department of Labor, which takes about 1 month or more to process. And then in the first few days of July of that year, you will need to file your H-2B visa application with the supporting documents and job order to the U.S. Department of Labor. And the registration period in July is strict, and if you miss those deadlines, then you will not be able to qualify to bring your worker on October 1st of that year. Now, if you plan to bring your worker with a start date of April 1st of any given year, then you need to start the H-2B visa process all the way in September, October, or the latest mid-November of the prior year. That is again because you will need to file a prevailing wage determination with the U.S. Department of Labor, which takes about a month or so. And then you are required to submit your application with the Department of Labor and supporting documents for your employee during the registration period, which is in January of that year. So if you miss the registration period and you don't have all the documents ready and the application and the prevailing wage determination during the registration period, then you will miss your opportunity to bring the employee to the United States on April 1st. Regardless of whether you will be submitting the application with the Department of Labor during the registration period in early July for employees starting on October 1st, or during the registration period in early January for employees starting on April 1st, you still have to go through the following steps to apply for the H-2B. 1. You must submit Form ETA 9141 with the U.S. Department of Labor in order to obtain a prevailing wage determination. 2. You must submit the application for the H-2B on Form ETA 9142B with supporting documents and job order to the U.S. Department of Labor during the registration period in July or the registration period in early January. 3. If the application is approved, you must conduct recruitment according to the Department of Labor instructions, which also includes posting on the Department of Labor website and the State Workforce Agency. 4. If the Department of Labor certifies the H-2B application on Form 9142B, then you must file Form I-129 with the United States Citizenship and Immigration Services requesting the H-2B workers, and you can file for multiple H-2B workers on one application in certain cases, of course. And 5, once Form I-129 is approved, then the worker, if they are outside of the United States, can apply for the H-2B visa at the U.S. consulate or embassy in the country where they reside and obtain an H-2B visa and come to the United States. If the worker is in the United States, then on Form I-129 you can actually file for change of status for them. Another visa program that you can use to bring foreign employees to the United States to work for your company is the EB-3 visa. The EB-3 visa suitable for this position is the EB-3 visa for unskilled workers because it requires less than 2 years of training or experience, for which qualified U.S. workers are not available in the United States. The EB-3 visa is for permanent work and you must offer your employee a full-time job. With the EB-3 visa, the employee will get permanent residency in the United States, also known as a green card, and also their spouse and children under the age of 21 will be able to obtain a green card as well. Now, the application process and the time it takes for the EB-3 visa process is long. It is about a year, even up to 1.5 years or more. But unlike the H-2B visa, you can start the process at any time during the year. In order to obtain the EB-3 visa for your employee, you as a company must take the following steps. 1. You must file a prevailing wage determination with the U.S. Department of Labor. 2. You must conduct recruitment that is specific to non-professional positions. 3. You must file a PERM labor certification application with the U.S. Department of Labor. 4. If U.S. Department of Labor approves your PERM application, then you can file Form I-140 with the U.S. Citizenship and Immigration Services. 5. If USCIS approves Form I-140, then the employee who is located outside of the United States can obtain a visa through their U.S. consulate abroad. Or if they are inside the United States, then they can apply for adjustment of status. Now, keep in mind that with respect to the application steps for EB-3 visa, there are strict deadlines that an employer must follow, and also there are strict requirements regarding recruitment. So it is important that you work with somebody who knows all these rules in order to avoid making mistakes that can cost you years into the process. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.